I've been warning that if the government can redefine your rights with a few lines of legalese, then the Second Amendment is only as strong as the next court willing to ignore it. Out in Kansas, a single traffic stop, an AR-style rifle, and a little Glock switch have turned into a federal showdown over whether so-called machine guns are even protected arms under the Second Amendment at all. Tonight, I'm going to walk you through how one federal judge said, yes, these are bearable arms and the government has to justify its ban, and how a panel of appellate judges came back and said, no, they're not, case closed. This is about whether courts can carve entire classes of firearms out of your constitutional protection by simply declaring them too dangerous to count. Right now, under 18 U.S.C. Section 922(0), it is a federal crime for an ordinary American to possess or transfer a machine gun, with only a few narrow exceptions for government use and certain pre-1986 registered guns. In plain English, if the federal government decides your firearm or your little metal switch meets its definition of a machine gun, you're not looking at a fine. You're looking at federal prison time. Section 922(0) is part of the Gun Control Act (GCA), and it functions as a de facto nationwide machine gun ban on ordinary civilians. The statute doesn't stand alone. Washington pairs it with definitions from the National Firearms Act and related regulations that treat any weapon that fires more than one round per trigger pull or any device designed to make that happen as a machine gun. That is how a Glock switch turns from a cheap piece of metal into a ticket to a felony indictment. But here's the key: after Bruen, the government doesn't get to say, we're scared of this gun. Therefore, it's banned. The Supreme Court has made clear that when the plain text of the Second Amendment covers someone's conduct, keeping and bearing a bearable arm, the burden shifts to the government. They have to point to this nation's history and tradition and show a real analog for this kind of sweeping prohibition. That is the legal terrain a decades-old federal machine gun ban facing a post-Bruen world where the government must justify modern gun laws with real history, not fear. In Kansas, officers pulled over a vehicle, and during that encounter, they discovered what the federal government says were two separate machine guns. The first was an AR-style Anderson rifle, chambered in .300 blackout, that ATF classified as a machine gun based on how it could fire. The second was a standard Glock handgun paired with a tiny metal device, a Glock switch, that Bruen, when installed, lets that pistol dump a magazine with a single pull of the trigger. From there, DOJ did what DOJ does. They reached for 18 U.S.C. Section 922(0) and hit the defendant with 2 felony counts of knowingly possessing a machine gun. The core accusation was simple possession of those items alone violated federal law. This is exactly where Bruen comes into the picture. Defense counsel did not just argue over technicalities. They said, in essence, these are bearable arms. They are firearms you can carry in your hands. Under Heller and Bruen, that means the Second Amendment's text covers them, and the burden is on the government to prove a historical tradition of banning them. That's how an ordinary traffic stop in Kansas turned into a test case over whether Washington can declare an entire class of modern firearms outside your constitutional protection simply by labeling them machine guns and treating ownership alone as a federal crime. At the district court level in Kansas, the federal judge actually applied the Bruen and Heller framework. Step 1. He asked the question Bruen demands, are the weapons at issue here bearable arms? Not. Do I like them? Not. Are they scary? But are they the kind of weapons a person can carry for purposes of confrontation? Looking at the Anderson AR-style rifle and the Glock with a switch, the court said yes. These are both firearms that can be carried by an individual. They fall within the ordinary meaning of arms. That meant the plain text of the Second Amendment covered Morgan's conduct. And once that threshold is crossed, Bruen is crystal clear the burden shifts to the government. DOJ had to come forward with actual historical analogs, real examples from our nation's founding or Reconstruction eras showing a tradition of banning mere possession of comparable weapons by ordinary citizens. The government tried, but the judge wasn't buying it. The historical evidence looked thin, scattered, and focused more on punishing misuse or especially dangerous behavior than on categorical bans on owning a whole class of bearable arms. And when DOJ leaned on that familiar line from Heller about dangerous and unusual weapons, the The court made an important distinction that language might matter at Step 2, the history and tradition stage, but it does not erase the fact that these are still arms under the text. In the end, the district court concluded that DOJ had not carried its burden. There was no solid historical tradition to justify treating Morgan's alleged machine guns as contraband simply because of what they were. On that basis, the judge took the extraordinary step of dismissing the indictment and holding the machine gun ban unconstitutional as applied to this defendant. The government appealed to the 10th Circuit Court of Appeals, and the case took a very different turn. On appeal, the Department of Justice advanced a familiar narrative, whatever Bruen might say about ordinary handguns. Machine guns are a distinct category. They argued that these weapons are not in common use for lawful self-defense, that they are exactly the sort of dangerous and unusual arms Heller said could be restricted, and that Congress's long-standing regulation of automatics proves there is no Second Amendment problem here. During oral argument at the 10th Circuit, the judges and the government's lawyers went back and forth over where common use belongs in the analysis. Is it part of the threshold question of what counts as arms under the text, or does it properly belong at the history and tradition stage Bruen describes? The panel ultimately treated common use as a kind of gateway filter, a way to keep certain weapons outside the Second Amendment altogether instead of a limitation that still assumes the weapon is an arm. The 10th Circuit panel largely accepted that framing. Instead of starting where the district court started, with the plain text and the question of whether these are bearable arms, the panel leaned heavily on the idea that machine guns occupy a special, disfavored category. Because they are heavily regulated and rarely possessed for lawful self-defense, the court treated them as effectively outside the core protection of the Second Amendment, in plain terms. The 10th Circuit treated Morgan's firearms as not arms under the Second Amendment's text at all, simply because they could fire automatically. In doing that, the panel did something subtle but incredibly important. It blurred Bruen's two-step discipline back into a threshold exclusion test, rather than saying, yes, these are arms. Now let's see if there is a historical tradition to support this ban. The court front-loaded the dangerous and unusual language and the not in common use concept to short-circuit the analysis. If the weapon is uncommon and scary enough, the Second Amendment simply doesn't reach it. End of story. Once it framed the case that way, the rest was predictable. The panel pointed to the National Firearms Act of 1934, the 1986 federal freeze on new machine gun registrations, and decades of federal enforcement as proof that there is a long-standing regulatory tradition surrounding these weapons. From there, it declared 18 U.S.C. Section 922 constitutional and reinstated the indictment against Morgan. After that ruling, Morgan's legal team took the fight to the next level and filed a petition for certiorari at the Supreme Court. In that filing, they accused the 10th Circuit of flipping Bruen on its head, shifting the burden back onto the citizen, treating common use as a way to dodge the plain text, and inviting lower courts to push unpopular firearms outside the Second Amendment by judicial label. They described this case as an excellent vehicle for the justices to correct those errors and to say, once and for all, how Bruen applies to so-called machine guns. And they warned that even under a Republican administration, DOJ is likely to keep defending these federal bans instead of defending the Second Amendment itself. So in one appeal, we went from a district court that treated the Second Amendment as real law to a circuit court that effectively said Washington can keep machine guns rare and heavily regulated, and the text doesn't get a vote. Morgan is not alone. Other machine gun challenges in cases like United States v. Rahimi show lower courts struggling with Bruen and signal that the Supreme Court will eventually have to say more about what the Second Amendment really protects. This matters because once a court says a particular firearm or accessory is outside the Second Amendment, the conversation is over. There is no need to find historical analogs. There is no burden on the government. The political branches can regulate that category into near extinction, and judges will wave it through by saying, well, those aren't protected anyway. That's the move you see in Morgan. Machine guns are rare and scary. Therefore, they can be banned. Therefore, they will remain rare. And that circular logic becomes its own proof. All of this happens while gun owners try to understand what is still lawful to own, carry, and use. Second, this case highlights how 20th century statutes like the National Firearms Act and the 1986 machine gun freeze are being treated as if they were founding-era guideposts. Instead of asking whether there were comparable bans at the time the Second Amendment was adopted, some courts simply point to modern-age post-New Deal regulations and call that long-standing tradition. For anyone who takes the Constitution's text seriously, that should be a red flag. Finally, Morgan is a warning shot for every gun owner who thinks, this is just about machine guns. It doesn't affect me. Once the government and the courts perfect the script for carving one category of firearm out of the Second Amendment by declaring it dangerous, unusual, and not commonly used for self-defense, the same playbook can be aimed at other semi-autos, magazines, or anything else politicians decide they don't like, whether or not the Supreme Court ever takes up this particular case. The issues it raises aren't going away. The real question is whether the justices will step in and remind the lower courts that the Second Amendment doesn't protect only the arms that survive 40 years of federal regulation. It protects arms, and the government is supposed to justify its restrictions, not the other way around. We've watched a simple traffic stop in Kansas turn into a constitutional fight over whether the federal government can write whole classes of firearms out of the Second Amendment by calling them machine guns and shifting the line on what counts as an arm. If you care about the right to keep and bear arms, this matters. I'll keep tracking Morgan and other post-Bruen cases where courts test your protections. Stay alert, stay engaged, and if you found this useful, subscribe and share it with someone who needs to see past the headlines.